Okay, welcome. Good evening, everyone, and hi. This is the last event in the Michaelmas term installment of our Talking Animals, Law and Philosophy series here. Thanks all for joining us. My name is Raphael Fizel. I am the Executive Director of the Cambridge Centre for Animal Rights Law. Just a few words on the format of these events for those of you who are joining us for the first time. We will start with a presentation by our speaker that will last for about 30 to 45 minutes. And we'll then have the rest of the time ending at 6:30 p.m. UK time for a discussion where everyone's warmly invited to participate. So if you have any questions for our speaker, or if you have any comments that you'd like to make, please do participate in the discussion. You're very welcome to do so. If you would like to participate, please use the raise hand function. It's the most convenient tool I'm finding to do so. You can find that under the reactions button, which should be at the bottom of your Zoom app. If you cannot find the raise hand function, you can also use the chat function to put in your questions or comments there if that's easier for you. But maybe if you can, try to use the raise hand one because it puts people in chronological order, which makes it a bit easier to go through the different hands. We are recording the presentation bit of this talk. So in case you would like to watch it later or have to leave midway through the talk, you can watch it on our website probably in a few days. Okay, I think with this out of the way, I can now introduce our speaker of tonight, and it is a great pleasure to have Joe Wills with us, who is a lecturer at Leicester Law School. Joe's research interests are in the fields of human rights and animal rights law, and in 2017 he published his first monograph with CUP entitled Contesting World Order, Socioeconomic Rights and Global Justice. In the domain of animal law, as many of you will know, Joe has published widely on topics ranging from the killing of animals to animal legal personhood, to the principles of animal welfarism, relationship between human rights and animal rights, as well as legal dimensions of veganism. In September, Joe drafted and coordinated the amicus brief that many other UK-based animal law academics have signed as well in support of the Non-Human Rights Project's habeas corpus petition on behalf of Happy and the case that is currently before the Court of Appeal in New York. Joe has also just completed a one-year Leverhulme Research Fellowship looking at the legal status of animals in Britain. And in his talk tonight, Joe will be exploring some of the themes that he tackled in this research fellowship with us in his presentation called Animals and the Common Law. Joe, thanks so much for being with us here tonight. It's a real pleasure to have you.
Okay, yes, thank you, Raphael. Can you hear me okay?
Yes, we can hear you, and the slides look great too.
Brilliant. Okay, so good evening. Thanks to the Cambridge Centre for Animal Rights Law for giving me the opportunity to discuss an aspect of my current research. As Raphael said, this is part of a broader project I've been working on over the last year on the legal status of animals in Britain. And today I'm going to be discussing the position of non-human animals in the common law. So perhaps the central question that's been at the heart of a great deal of animal law scholarship and practice is, how does the law view animals? Are they objects to be used as resources or subjects to be respected and protected? And in this presentation, I'm going to be exploring how this question has played out in common law cases involving animals. Now, I expect that this audience will be varied. Some of you will be lawyers and others not. So I'm not going to assume any specialist knowledge here, and I'll begin by defining what I mean by the common law. So in the West, we can broadly identify two types of legal systems: civil law systems and common law systems. Now, roughly stated, civil law systems are jurisdictions such as those in continental Europe, which have where the sources of law are exclusively, or at least predominantly, derived from codified sources such as constitutions, statutes, and criminal and civil codes. By contrast, in common law jurisdictions, such as England and its former colonies like the US, Canada, India, New Zealand, and so forth, a significant proportion of the law is derived from the decisions of judges that have been made over the years, and this judge-made part of the law is known as the common law. And the common law is a pretty significant source of law in many common law countries. So, for example, in England, most of tort law and contract law, as well as large parts of constitutional and administrative law, as well as criminal law, are derived from and part of the English common law. Okay, so as I've said, the common law is judge-made law, but this does not mean that an individual judge can make any law they want. Right? They're constrained by a number of things. Perhaps most significantly, they're constrained by legislation. So this means that when there's a legislative norm and a common law norm that conflict, the legislative norm prevails. So in England, we have the doctrine of parliamentary sovereignty. And this means that when there's a clash between the common law and a provision in an act of parliament, the common law is effectively overruled. And conversely, the common law can't overrule any piece of legislation. Secondly, judges are constrained by a system of what's known as precedent. And this means that in most cases, at least, judges are bound to follow decisions that were previously made in similar cases. The common law isn't completely static, though. For a start, senior courts have the right to overrule their earlier rulings, either because those rulings were made in error or because they're no longer appropriate due to changing circumstances in society. And moreover, lower courts frequently encounter novel disputes and have to accordingly apply existing precedent to these new, unique situations. And so there's, a measure of flexibility in that. So in theory, at least, the common law is meant to be both orderly and predictable on the one hand, while also having a certain degree of adaptability and flexibility on the other. Okay, now let's say a little bit about the historic position of animals in the common law. So the status of animals in English common law has historically been influenced by kind of two main sources. On the one hand, by Roman law, which divided legal entities into the categories of persons and things. And the Roman law notion of a thing can be roughly understood as what we would now call property. So something that has economic value, something that can be traded or possessed or owned. And within Roman law, animals were unquestionably things. And within this Roman law system, the sort of bundle of rights an individual has in an animal depends on how that animal is classified. And there are different bundles of rights associated with domesticated animals on the one hand, and a more restricted bundle associated with wild animals on the other. And this distinction has been incorporated into the English common law. There are treatises going back to the Middle Ages that affirm this principle, and a string of kind of broken case law that goes at least as far back as the 16th century. The other main source informing the status of animals at common law has been the Bible. and in particular, the Old Testament notion found in Genesis 1:26 of human dominion over the natural world. And we find this idea in the writings of, say, the 17th century jurist William Blackstone, and political philosophers like John Locke, who use it as a sort of justification for inheriting this property status of animals from Roman law. Now, these kind of ideas have informed a long line of cases coming up to the present, although these days religious justifications are seldom invoked. Okay, but whilst the English common law provided mechanisms for enforcing the rights and liability of animal owners, it historically didn't provide any direct forms of protections to animals themselves. Now, an owner could sue a third party for injuring or killing or harming one of their animals without their consent, but the animal themselves received no protections at the hands of their owner, and wild animals were largely unprotected in any way. Sorry, my mouse is, okay. And so I call this traditional approach to animals the mere property approach. And this mere property approach treats animals, for all intents and purposes, as indistinct from insentient chattels. The subjectivity of animals, their interests, their welfare are completely disregarded and regarded as legally irrelevant. Now, given this traditional common law classifications of animals as mere property, the introduction of animal protective measures have largely been the role of the legislature over, say, the last 200-year period. So hence we have laws forbidding certain forms of treatment of animals, prohibiting cruelty and unnecessary suffering, and setting certain minimum standards of treatment. Now, it's important to note that these statutory welfare laws don't abolish the property status of animals, but they do modify it to a degree by placing restrictions on the various kinds of use that the owners of animals can engage in. And I call this the sentient property approach. So this approach, whilst recognizing that animals are property, identifies a unique, that they're a unique form of property by virtue of their sentience, which entitles them to a certain level of protection. So owners not only have rights in relation to their animal property, but they also have, at least in theory, a certain level of obligations to those animals as well. So, on the one hand, we have a traditional common law approach that treats animals as mere property, and a statutory approach that treats animals as sentient property. For some, this arrangement is the correct one. So they believe that the baseline approach of the common law should be to uphold the rights and liabilities of animal owners, and to the extent that any limitations are placed on that ownership to protect animals, this is a job for the legislature. I call this the dualistic view of animal legal status in common law countries. So on this view, courts must completely ignore animal welfare and animal interests unless they're expressly authorized to consider them by the legislature. Or alternatively, if there's a private agreement amongst the litigants, so a contract in which animal interest or welfare are a term, courts can enforce that. But outside of those exceptions, that they have to completely ignore animal welfare in cases involving animals. Now, an alternative way of thinking about the relationship between the common law and statutory approaches to animals is what I call a convergence view, or a dialogical view. And on this view, the common law should evolve in line with legislation to reflect changing moral, social, and legal norms concerning the position of animals in society. Consideration of animal interests and animal sentience, on this view, shouldn't be the sole task of the legislature. The courts too should take these things into consideration, even when they're not explicitly required to by legislation. Okay, but what could a common law more attentive to the interests of animals look like? So in recent years, there have been efforts by animal advocates to get the courts to move away from a mere property approach to animals. And some of these have achieved a relative degree of success. First, in disputes over animal ownership, such as who gets to keep a companion animal following the breakdown of a relationship, litigants have argued that that rather than simply asking who has ownership rights in the animal, the courts should adopt a framework more akin to resolving a custody dispute over a child and give primacy to the welfare needs of the companion animal. So in the United States and New Zealand, multiple courts have indeed broken with this traditional property analysis and adopted a best interests of the animal test, or alternatively, a best for all concerned test, to determine who should get custody of the animal. So implicitly recognizing that animals are more than mere property. By the way, this photo isn't a photo of a dispute over a dog. It's actually it's Chris Green and Kristen Stilt of the Harvard Animal Law program posing for a photo shoot, but I just wanted to include it because of the dog in the court picture. Okay, another area where courts have moved away from a mere property approach in common law disputes has been in cases involving the calculation of damages to be awarded where a companion animal has been wrongfully injured or killed. So historically, companion animals have been viewed by the courts as personal property, and typically when personal property is involved, damages are limited to fair market value. But again, over the last couple of decades in the US and Canada, growing numbers of courts have allowed for recoveries for non-economic damages. And these have included, for example, veterinary expenses, recovery for loss of the intrinsic value of the animal, damages for sentimental loss arising from the wrongful killing of an animal, and damages for mental suffering to the animal's owner. And I think these rulings at least implicitly recognize that animals are distinct from other types of personal property, which typically can be compensated for only in terms of market value. Now, one recent common law challenge in the US that takes this damages approach one step further has actually involved suing for damages directly on behalf of animals themselves. So in Oregon, an owner of a sanctuary has brought a common law negligence per se claim on behalf of a horse called Justice that she's looking after. Incidentally, I can see that people involved in the case are in the audience, so it's great to have you here. This horse was severely neglected by his former owner in breach of Oregon's anti-cruelty laws, and as a result requires lifelong care in the sanctuary. And the sanctuary are arguing that the horse's former owner is required to pay damages to the horse to cover this ongoing care. And I believe that this case is presently awaiting a ruling. One final example that I'm sure many of you are familiar with is that of the US-based Non-Human Rights Project, who are attempting to get the common law writ of habeas corpus extended to certain non-human animals. Now, the writ of habeas corpus is a legal remedy designed to challenge the lawfulness of a detention. The Non-Human Rights Project are presently awaiting a hearing before New York's highest court, in which they argue that an elephant is being unlawfully detained in the Bronx Zoo, and that they're entitled to be released to an elephant sanctuary. Now, this is quite a bold legal argument, but it's garnering some judicial support already. So in 2018, Justice Fahey of the same court, the New York Court of Appeals, said that the issue of whether a non-human animal has a fundamental right to liberty protected by a writ of habeas corpus is profound and far-reaching. Ultimately, we are not going to be able to ignore it. And writing in support of the Non-Human Rights Project's current case, a retired South African constitutional judge called Edwin Cameron has said that developing the common law to extend legal personhood to non-human animals is a legally sound approach. Now, I think what's noteworthy in all of these examples I've just given is that none of the litigants have expressly contested the property status of animals in law. And this is not, I think, because typically these litigants are sympathetic to the property status of animals or view it as desirable or right, but rather, I think, because they realize that there's, given how entrenched the property status of animals is, both in the common law and also in various statutes that there's, and constitutions and so forth, there's very limited chance of getting it overturned through the common law. So instead, what they seek to do is reduce or minimize the significance of this property status by focusing on the unique position of animals and instead redirecting energy towards focusing on their subjectivity and sentience and the legal relevance of that. So in some cases, courts are beginning to adopt the common law in certain ways to recognizing aspects of animal subjectivity. In other cases, the courts are resisting doing this. So I think an interesting question to ask at this point is, what are the values of the common law and how do or should they affect questions relating to the legal status of animals? Now, of course, this is a really big jurisprudential question, which I don't intend or have any illusion that I'll resolve here, but I think nonetheless a useful starting point for thinking about this question comes from the work of a US scholar called Melvin Aaron Eisenberg. And Eisenberg identifies kind of 3 values that he thinks are core or at the heart of the common law. He calls them social congruence, systematic consistency. I'm going to refer to systematic consistency as legal coherence, and finally doctrinal stability. Now, I'm going to explain what these mean shortly. Eisenberg has a certain jurisprudential theory to explain why these values are so central to the common law. That's not a particularly important issue for me. What really matters from my point of view is that in deciding common law cases, including common law cases relating to animals, judges do frequently, either directly or indirectly, appeal to these values. Okay, so let's start with social congruence. Social congruence refers to the degree to which legal rules conform to societal standards. Now, these societal standards include moral norms relating to what's right or wrong, public policy considerations about good and bad outcomes, and empirical propositions about what's true and false. So just a quick word about moral norms here. Moral norms being referred to aren't necessarily norms that reflect an objective morality, as it were. Rather, moral norms here refers to the norms that are kind of held broadly or widely in society, as well as the types of moral norms and values that are kind of deeply embedded in a legal system. So this might include things like liberty, equality, democracy, procedural regularity, fairness, etc. So why is it important for there to be a degree of congruence between these societal standards and common law rules? I think there are at least 2 reasons. The first relates to the functionality of law. So the responsiveness of the common law to social norms kind of enables it to provide a system of justice that's relevant to the times in which individuals live. In other words, the more a legal system's standards are disconnected from those of the wider public, the more irrelevant the law becomes to their lives. The second reason why social congruence matters relates to the common law's legitimacy. So when it comes to legislation, part of the legitimacy of legislation comes from the fact that the people who pass it are elected and hence have a degree of representative authority and accountability. Judges, by contrast, aren't elected. So the legitimacy of the decisions they make that affect our lives is closely connected to their ability to resolve disputes in a manner that commands broad support in society. Okay, so how does the value of social congruence relate to animals? So I think the value of social congruence suggests it's a mistake for courts to address common law questions involving animals in a sort of very formalist manner that draws this sharp dividing line between an animal's social and legal state, social and moral status on the one hand, and their legal status on the other. Instead, I think judges should have appropriate regard for wider societal and legal values when it comes to animals. And this is important, I think, because it must be remembered that the common law view of animals has a genesis that dates back thousands of years, right, long before the Darwinian revolution. So under the influence of Aristotle and Aquinas, this old view was that humans and animals are entirely separate and that there's this divinely authorized hierarchy between them. I think now we know that humans are animals and that the other species are our genetic and evolutionary kin. So exactly what the value of social congruence entails in respect of the common law is going to involve how the common law relates to animals is going to depend on the particular case and the particular issue being contested. But I think at a minimum, it means that courts should reject a mere property approach that treats animals as no different to insentient chattels. And because this seems to me to be glaringly at odds with the values of social congruence. And this was a point that I think was made well in a concurring judgment by Justice Andel from a Texan case called Buchner and Hamill. And I think I'll just read this quote at full because it really captures nicely, I think it drives home the point nicely. Okay. They say, the law must be informed by evolving knowledge and attitudes, otherwise it risks becoming irrelevant as a means of resolving conflicts. Society has long since moved beyond the untenable Cartesian view that animals are unfeeling automatons and hence mere property. The law should reflect society's recognition that animals are sentient and emotive beings that are capable of providing companionship to the humans with whom they live. In doing so, courts should not hesitate to acknowledge that a great number of people in this country today treat pets as family animals. Indeed, for many people, pets are the only family members that they have. I think that sort of captures the idea nicely. Okay, next we have legal coherence. So legal coherence is the idea that the different rules that make up the legal system should be as harmonious with one another as possible. So this means that legal rules shouldn't embody contradictory values to one another. And I think what's important really is that contradictory values should be mitigated and minimalized to the greatest extent possible. So just to draw this out, let's imagine that there's a jurisdiction, and in this jurisdiction, there's one legal regime governing the coal industry that imposes regulations and taxes on them designed to mitigate their adverse environmental impacts. Now imagine in the same jurisdiction, there are no such regulations and taxes placed on the oil industry, despite the fact that it also has these adverse environmental impacts. Now, although there's not a kind of contradiction in the technical sense between these two regimes, they're nonetheless incoherent, right? Because they arbitrarily value environmental protection in one instance, but not in a comparatively relevant other instance. And so legal coherence is important for a variety of reasons. Firstly, it demonstrates the formal rationality of a legal system. It also strengthens a substantive rule of law norm that like cases should be treated alike. And it also enhances legal certainty because the law's more predictable when it embodies more unified values, amongst other things. Okay, so how does this relate to animals in the common law? So as I indicated earlier, there are a variety of statutory forms of protection of animals, and these clearly recognize animals as distinct from mere property. So accordingly, adopting a mere property approach at common law seems out of step with this legal recognition of the salience of animal sentience and animal welfare in statutory law. And again, a point that was made, I think, quite nicely in the New York Supreme Court Appellant Division in the case of Fager and Warwick Animal Shelter. And again, if I may, I will just read out the quote. This state has a long-standing history of protecting animals. The reach of our laws has extended to animals in areas that were once reserved only for people. These laws indicate that companion animals are treated differently from other types of property. Recognizing companion animals as a special category of property is consistent with the law of the state and the underlying policy inherent in these laws to protect the welfare of animals. So the idea here then is that it seems that the values and policy rationales underpinning the statutory protection of animals should find some expression in the common law too. Now, I think something further needs to be said about this, because I could imagine a critic objecting and pointing out, look, there's nothing inherently incoherent about leaving it to the legislature to determine rules governing the welfare and interests of animals in society. And I think in response, what I'd say is that legal coherence concerns the sort of the congruence of values across laws, not the congruence of the rules themselves. So Ronald Dworkin famously contrasted rules from values by pointing out that whilst rules are kind of hard and fast, values or principles have a sort of gravitational force in legal decision making. And the legal coherence claim is that this gravitational force of the importance of animal protection, animal welfare, animal interests should reach into the common law as well. So a mere property approach at common law that treats animals no differently to insentient chattels would cohere badly with animal protective legislation because of the different values that these two legal kind of regimes embody. Okay, this finally takes us on to doctrinal stability. Now, doctrinal stability basically means that the law should be stable over time so that its established doctrines are not changed too quickly or in an erratic manner. Now, doctrinal stability is maintained by the common law through judicial precedent. So to the extent that kind of the common law changes at all, such changes should be incremental rather than radical in nature. So doctrinal stability is regarded as an important value because it helps litigants and their advisors to assess the nature and scope of their existing legal obligations. This in turn promotes more legal certainty, more predictability, and it also enables litigants to participate more effectively in the legal process because they're aware of the arguments and the counter arguments and so on. Doctrinal stability also reduces the amount of litigation clogging up the courts because settled areas of law are less likely to be contested before the judiciary. And finally, doctrinal stability reduces instances of retroactive law. So when the common law changes, these changes are imposed retrospectively on the litigants in the case. I mean, this can actually be avoided by the judges issuing a prospective judgment, which means that the judgment will only take effect, after, it won't affect the parties directly in the case. This doesn't completely reduce retrospectivity, though, of course, because people who are not party to the disputes have already made decisions in accordance with what they regard the law to be. So it doesn't, these sort of prospective judgments don't get rid of doctrinal, don't get rid of retrospective law, but they do minimize it somewhat. Okay, and I think the reasons for not having retrospective law should be fairly obvious. Okay, so how does doctrinal stability apply in relation to animals? So doctrinal stability is really the conservative dimension of common law adjudication. And I think it does have implications for how far the common law can go, or at least is likely to go when it comes to more animal-friendly readings. So where there's a long line of precedent that has, explicitly excluded consideration of animal interests from common law doctrine, there's not much the lower courts can do about this. And even when it comes to higher courts or lower courts hearing novel cases, there's almost invariably going to be, a cautiousness and a hesitancy to developing the common law. I mean, that applies at least in Western common law jurisdictions. I think in India and Pakistan, we've seen some very kind of bold and path-breaking judgments, at least on paper. But the value of doctrinal stability doesn't mean that that the common law can never be made more responsive to animal interests, or it doesn't rule out that. So incremental development of the common law is possible. And I think kind of recognition of animal interests in separation proceedings in certain US states and New Zealand are good examples of this. But in other instances, kind of bolder claims will give courts more pause for thought. So take here, for example, the Non-Human Rights Project's efforts to get habeas corpus extended to other animals. So last year, the first department of the Appellant Division dismissed the Non-Human Rights Project's habeas corpus position on behalf of an elephant on the basis that, quote, a judicial determination that species other than Homo sapiens are persons for some jurisdictional purposes and therefore have certain rights would lead to a labyrinth of questions that the common law processes are ill-equipped to answer. Now, I think this is pretty vague, but I suspect what the first department's getting at here is that opening the door to extending the common law personhood to other animals is going to involve these difficult line drawing questions. If personhood is extended to animals, to elephants, for example, what other species would it extend to? However, I think it's also important to stress that doctrinal stability isn't the only common law principle. Sometimes courts develop the common law in spite of generating more doctrinal uncertainty. So I think most famously in 1932, the UK House of Lords more or less established the common law doctrine of negligence. And this generated a huge amount of uncertainty initially, but over time it's stabilized and become one of the central pillars of private law in common law countries. Moreover, sometimes the value of doctrinal stability is going to be in tension with the other values I mentioned, social congruence and legal coherence. So in some instances, courts are going to have to strike a balance between these competing values. And I think a sort of really useful example of this is the overturning of the common law marital rape exception by the English and Scottish courts in the late 80s and early 90s. So there was this well-established common law rule, dating back hundreds of years, that the offense of rape could never be committed by a husband against his wife. And Scotland and England's senior courts were faced then with this legal norm that was both firmly established, but also utterly morally odious. So the traditional common law doctrine was completely out of step with social norms, and it was also, out of step with a whole host of laws prohibiting discrimination on the basis of sex. So England and Scotland's top courts accordingly responded by ditching the common law rule, despite the fact that it was fairly well established at that point. So sometimes the values of social congruence and legal coherence are going to trump doctrinal stability. Now, of course, this is very much what groups like the Non-Human Rights Project seek to argue. They point to changing social norms and evolving scientific understandings of the minds of animals like elephants and chimpanzees to argue that, keeping them in cages is just incompatible with common law values like liberty and equality. But I think, the Non-Human Rights Project are under no illusion that winning these sorts of cases isn't easy, which is why they've developed a focused and targeted strategy of relitigating these habeas corpus suits, gaining concessions along the way and building on them. And I think any attempt to, advance sort of to make bold advances in the common law is going to require this sort of laser-focused dedication and commitment that the Non-Human Rights Project have demonstrated. Okay. Just to summarize then. So this presentation has looked at some of the core underlying values and principles of the common law. It's argued that some of these values call into question the mere property approach to animals that the courts have adopted. This mere property approach is out of step with societal attitudes towards animals, which, although far from consistent, accept that animals are sentient beings entitled to at least some protection. The mere property approach to companion animals, I think, is even more out of step with public attitudes. Finally, the mere property approach is also hard to reconcile with statutory animal protection regimes that clearly recognize that animals have interests and welfare to be protected. However, the value of doctrinal stability places limits on what can likely be achieved for animals through the common law. Efforts at structural or regulatory reform are probably best left to the legislative process. But nonetheless, the common law is still an important site of contestation concerning the legal status of animals. And strategic interventions designed to make animals and their interests more visible in the law are valuable, even if it's just to stimulate public debate. And I think, again, that the sort of example of the Non-Human Rights Project is illustrative here of the sort of amazing kind of public attention their cases have generated and the big debates that they've sparked. Okay, I think I'll end it there. Thank you.